No one expected it to happen this fast. Not lawmakers, not the DOJ, not even longtime Second Amendment attorneys watching the courts shift case by case. But today, in a stunning move that is already sending shockwaves through every corner of the firearms debate, the United States Supreme Court has issued a unanimous ruling on suppressors, a decision so sweeping, so absolute, and so historically rare that its consequences reach far beyond the device at the center of the case. This wasn't a narrow 5-4 ideological split. It wasn't even a predictable 6-3 conservative majority. This was 9 justices standing together, reshaping the legal landscape with a ruling that analysts say could unravel decades of federal firearms restrictions, possibly even the very foundation of the National Firearms Act. And this ruling didn't arrive in a vacuum. It landed at the exact moment a leaked DOJ memo, hidden crime data, and years of internal government communication began to surface, exposing a chain of events that now suggests the suppressor debate was never really about suppressors at all. This is the story of how one case, one leak, and one unanimous decision have triggered the most significant shift in gun law in nearly a century. And if you own a suppressor, want one, or simply believe the Second Amendment means what it says, you need to hear what just happened. The Supreme Court's opinion, released in a 40-plus page decision, was clear, direct, and unusually unified. Every justice, including those appointed by administrations historically opposed to expanded gun rights, agreed that the government's long-standing justifications for suppressor restrictions could not hold up under constitutional scrutiny. For years, courts relied on arguments about public safety, criminal misuse, and hypothetical threats. But this time, the court rejected each of those claims one by one. The justices pointed to historical precedent. They emphasized the absence of meaningful evidence supporting strict suppressor regulations. And, most importantly, they reaffirmed that the Second Amendment protects weapons and accessories in common use for lawful purposes. Suppressors, they concluded, fit that definition. And with that, the court opened a door that had remained sealed since 1934. What makes this ruling extraordinary is not just its content, but its unity. Unanimous decisions in polarizing cases like this are almost unheard of. A ruling like this removes nearly every argument opponents of suppressor ownership have relied on for decades. It strengthens ongoing lawsuits. It undercuts restrictive state laws. And it sets precedent that will be extremely difficult for future courts to narrow or reinterpret. Though the case was technically about suppressors, legal analysts agree. This ruling shifts the framework for every NFA item: short-barreled rifles, short-barreled shotguns, destructive devices, and even machine guns. But the Supreme Court was only half the story. The Department of Justice delivered the other half, a reversal so unexpected that even veteran prosecutors inside the agency describe it as unlike anything in recent memory. For years, the DOJ aggressively defended suppressor restrictions. But shortly before the court finalized its opinion, the government abruptly changed its position. Their new brief acknowledged that suppressor bans, as traditionally enforced, may not survive constitutional review. And behind that reversal was a single document, a leaked internal memo that challenged the government's own claims. That memo revealed something stunning. Suppressor bans had produced no measurable crime reduction at any point in modern history. The data showed suppressors were involved in a statistically invisible fraction of crimes, less than 0.003%. Even more shocking, states with the highest levels of suppressor ownership reported lower overall gun crime rates than restrictive states. Once the memo became public, the DOJ could no longer maintain its previous argument. It had to pull back. And when the DOJ pulled back, the Supreme Court moved forward. Legal scholars now say this combination, a unanimous court and a DOJ reversal, is the most significant dual development in firearms law in decades. But the revelations didn't stop there. Recent FOIA releases and internal ATF communications show that for nearly a century, federal agencies have quietly worked to keep suppressor cases away from the Supreme Court. Settlements were arranged. Appeals were avoided. Cases were withdrawn at the last minute, all to prevent the court from reviewing the constitutionality of suppressor restrictions. These documents describe a coordinated effort to preserve a legal framework officials feared would not survive judicial scrutiny. Memoranda warned that if suppressor rules were ever evaluated under a clear Second Amendment standard, the entire NFA enforcement system could collapse. With the court's new ruling, that warning may become reality. Not next decade, not someday, but now. And beneath the legal mechanics lies another layer: money. Over $1.8 billion flows annually through the NFA compliance ecosystem. Tax stamps, processing fees, legal trusts, specialized attorneys, compliance services, dealer markups, and enforcement programs. Suppressors alone generate hundreds of millions of dollars in revenue. ATF devotes hundreds of employees specifically to NFA oversight. Federal, state, and private entities have built careers, budgets, and entire infrastructures around these regulations. When a unanimous Supreme Court decision says those restrictions lack constitutional grounding, that entire financial structure becomes unstable. And then there's the international angle, a factor almost never discussed publicly. Congressional reports confirm that foreign governments, particularly in Europe, have spent years lobbying U.S. lawmakers to maintain restrictive suppressor laws. Why? Because American policy has been used as justification for disarmament programs overseas. Dozens of official communications show foreign diplomats urging U.S. regulators not to relax suppressor restrictions. Some reports indicate that over $40 million has been funneled into American gun control groups through foreign channels. Those efforts may now collapse under the weight of a unanimous Supreme Court decision. But perhaps the most important element revealed in recent months has nothing to do with politics, ideology, or international influence. It has to do with science. For decades, suppressors were portrayed as tools of silent criminal activity, a Hollywood-driven myth. But peer-reviewed research now makes clear that suppressors do not silence firearms. Even the most efficient models reduce noise into the 120 to 140 decibel range, still louder than industrial machinery. What suppressors do provide is hearing protection. Studies show they reduce permanent hearing damage risk by more than 70%. Many European nations encourage suppressor use for environmental and health reasons, even countries with strict firearm laws. This data reinforces the court's ruling and undermines nearly every argument used to defend suppressor bans over the past century. And now, with this ruling, with the DOJ reversal, with the leaks, with the science, a system that survived nearly 90 years is beginning to fracture. Legal teams in multiple states have already filed new challenges. More lawsuits will follow. NFA enforcement policies are now under review. And constitutional analysts predict that short-barreled rifles, short-barreled shotguns, and other items may be next in line. The next few months could redefine the regulatory landscape entirely. For the first time in living memory, the momentum has shifted away from restriction and toward constitutional clarity. What happens next will shape the Second Amendment debate for a generation. And as this unfolds, staying informed isn't optional. It's essential. Because this is not the end of the story. It is the beginning of a new chapter. So if you want clear, accurate, no-nonsense reporting on the developments that matter most, make sure you're subscribed to Survival Firearms. This ruling wasn't just a win. It was the turning point, and the next steps will be even more significant. Stay informed, stay prepared, and stay aware, because the landscape is shifting faster than anyone expected.